presiding would be to make provision for any of the purposes specified in paragraph A of this article. My lords, from the reading of Article 108, the plaintiff is of the considered opinion that Parliament was caught by, or the person presiding was caught by Article 108A I, and then III.
Roman 1, Roman 2, Roman 3.
Roman 2, Roman 3. Lady, despite the limitations imposed on the
Parliament
was caught.
Caught.
Yes.
CAUGT.
By the provisions of Article 108.
What does caught mean?
What we mean is that there were limitations placed by the Constitution on the exercise of the powers of the person presiding. And so these constitutional limitations were supposed to constrain Parliament from proceeding any further with the bill. But that was not the case. The bill proceeded. And
Council, can you explain what the limitation you are talking about is, please?
And lady, respectfully, the limitation is simply that Parliament shall not proceed if a bill is not introduced by the President. Then, if a private member introduces the bill, then there should be prima facie an analysis of the bill to see if it imposes a financial implication on the public purse. If it does, then Parliament cannot proceed. That is the meaning we place on Article 108.
Your summary seems to skip a few salient points. Can you quote what the Constitution says in that regard?
It says that Parliament shall not proceed if the bill imposes a charge on the consolidated fund or other public funds of Ghana. That is 108A Roman number 2. That is what it says.
You read more than that, Council.
Yes, but
can you give a faithful rendition of what the Constitution says instead of just picking and choosing?
So Roman, to go back to your submissions, A says that Parliament, 108 says Parliament shall not, unless the bill is introduced by the President. And A says that proceed upon a bill, including an amendment to a bill, if in the opinion of the person presiding, it makes provision for Roman 1, the imposition of taxation or the alteration of taxation, otherwise than by reduction. What does that mean? I believe that's the question being asked.
Yes, we are not grounding our case on AI, but on number 2 and 3.
And 2 reads?
2 reads the position of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction. And
does the 2 stand by itself, or it is controlled by the part that was read by her ladyship?
Yes, my lady, it is controlled by the preceding paragraphs.
Give a faithful rendition of it so we follow your argument.
In my own words, or I should read from the Constitution?
Just to assist, Parliament shall not, unless the bill is introduced or the motion is introduced by on behalf of the President, proceed upon a bill including an amendment to a bill that, in the opinion of the person presiding, makes provision for any of the following. And you say you are grounded on Roman 2. Yes. The imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge, otherwise than by reduction. So,
and then 3.
What does this mean?
Lady, what it means is that if a bill is introduced in Parliament, which is not by the President, there must be a fiscal impact analysis. So the fiscal impact analysis must accompany the bill. And then based on that fiscal impact analysis, the person presiding looks at it and say, if the bill says we are going to arrest and detain people, even the trade trial processes will incur some cost. And so if that analysis is done and it accompanies the bill, then the person presiding is in a position to say that this bill cannot proceed. It being coming from a private member, but not the president. Because the essence of the law is that Parliament checks the public purse, but it does not spend the public purse. It does not tell the executive how to spend the money of the country. It is the executive that decides to spend, and Parliament acts as a check. And so this provision is acting as a check or a limitation on members of Parliament that want to rule the country from Parliament. It is the executive that rules, not Parliament. And so the essence of the bill is saying that if you want to introduce a bill, that is fair enough. But make sure that that bill does not impose a charge on the public purse, because the executive that determines how the money of the country is spent. And so if a fiscal impact analysis is placed before Parliament, the person presiding does not make an opinion arbitrarily, but in a fair and candid manner to say that I am guided by this, it imposes a charge on the consolidated fund, and therefore we shall not proceed with this bill.
So how does what you have read tie in with the specific facts of this case? That is what I think we...
Yes, my lord, the specific facts of this case is that when the bill was first introduced, there was no fiscal impact analysis. When it was first read, it was referred to the Constitutional, Legal, and Parliamentary Affairs of Parliament. So the Constitutional and Legal Committee sought the opinion of the second respondent. And the second respondent, in a letter...
the Attorney General.
The Attorney General, my lords. And in a letter dated the 19th of October 2022, with reference number LI 7/2021, the Attorney General, specifically on page 5 of that report, clearly stated that it is observed that the bill...
I don't like the language. Did you say observed or observed?
Lady, I'll read it for you.
Read. It's exhibit.
Lady, this is exhibit A1.
Yes.
Lady, and it is paragraph 1, 2, 3, 4, 5, 6.
Paragraph 6.
Paragraph 6.
On page.
On page 5. And the advice reads, it is observed that the bill is not accompanied by a fiscal impact analysis required by Section 101 of Act 921. The stipulation in Section 101 of Act 921 is rendered more imperative by the character of the bill as a private member's bill. So this is the advice as attached to Exhibit A1. Yes, my lord.
The observation is the advice?
It's an observation, but it goes on to say, it analyzes the bill one by one, and then even before this paragraph, the advice says, that is paragraph, starting from paragraph 3. It says, thus, the passage of the bill is subject to subparagraph 3 of paragraph A of Article 108 of the Constitution. A determination of the satisfaction of the conditions in Article 108 ought to be made objectively by the person presiding over proceedings in Parliament on the basis of analysis properly conducted by proponents of any bill in question. Yes. And it goes on, it is for this reason that Section 101 of the Public Financial Management Act 2016 stipulates that any legislation to be laid before Parliament or proposal submitted for the approval of Parliament shall be accompanied by a fiscal impact analysis stating the estimated effect on revenue and expenditure for the financial year in which the legislation or proposal is expected to come into effect. My lords, what we are saying is that despite this advice, the bill proceeded in Parliament, despite also the pendency of this application or this writ, which was issued on 1st June 2023 before you, Lord, the bill proceeded, And at various times, there were statements to the effect that Parliament will pass the bill willy-nilly, despite the advice and despite the pendency of this suit. My lords, we are aware, I'll turn to our statement of case. As I've noted earlier, we rely on our statement of case, which is an 80 paragraph statement of case. But we also wish to make a viva voce explanation of the points we have raised. And my lords, I want to tie it in with the response by the first respondent, because we are going to argue that the conditions for the grant of an injunction to restrain the Impunity Act is rife, it is present, and we'll tie it with the response or the affidavit in opposition by the first respondent. My lords, the affidavit in opposition filed by the first respondent on 20th May 2024, pursuant to the order of this court on May 8th, 2024, is not accompanied by a statement of case. The statement of case was not filed, but the first defendant respondent attacks our application, and we sum their attack on our application on 5 major grounds. First, that the present application for injunction is materially the same as the application which was dismissed by the court on 19 July 2023. It states that in paragraphs 9 to 18. Secondly, they say the President has expressed an unwillingness to assent to the bill, paragraphs 19 to 22. They also talk about the fact that the grounds for the...
To 9 to 18.
Yes, maybe.
I believe you first referred to the essence of paragraphs 9 to 18.
Yes.
Kindly go back to that.
Yes. The point we are making is that their claim, or in sum, what they are saying in paragraphs 9 to 18 is that the present application for injunction is materially the same as the application which was dismissed by this court on 19 July 2023. Then, in paragraphs 19 to 22, paragraphs 19 to 22, the essence of what they are saying is that the President has expressed an unwillingness to assent to the bill. That is paragraphs 19 to 22. Then they go on to say in paragraphs 29 to 30 that the grounds for grant for an order of interlocutory injunction have not been proven by the applicant. And then, finally, in paragraphs 23 to 27, they say that the report of the committee indicates that the AG's concerns have been addressed. 23, my lady, to 27, they allege that the report of the committee indicates that the AG's concerns have been addressed. My Lord, and one final point, they also claim that the fiscal impact analysis has been conducted. Paragraph 28. Lord, it is this that we now turn our attention to respond to and then tie it in with our own legal submissions. Yes. My lords, the first point that the present application is materially the same as the previous one is inaccurate. At the time of the hearing of the first application for injunction in July 2023, the bill was still being considered in Parliament, and indeed, we have attached Exhibit A2, which suggests that the Speaker had directed that the bill be conceded either on the 23rd or the 27th of July, despite the pendency of the writ and the application for injunction. Lord, at the time of filing this present application, the work of Parliament in terms of considering the bill is completed, and Parliament has attempted to transmit the bill to the President. And my Lord, our point is that there is a changed circumstance, a material change circumstance, in fact, in law, and the fact that a previous application has been dismissed does not prevent us from bringing another one if the material facts have changed. And indeed, we are fortified by the case of Ajikum versus Asekum Engineering and Construction Limited. Ajikum versus Asekum Engineering and Construction Limited. Lord, is a 1989-1992 Ghana Law Report at page 650. Lord, and clearly this court made it clear that the fact that an application has been dismissed earlier doesn't mean that when the change, there are circumstances that change, another application cannot be brought before the court. Lord, if I may read what this court said in that case at page 650. You see,
Page
650. Lord, the court said.
Did you say 650?
650, my lady. It reads.
No, the citation I got from you.
Yes, my lady.
Is 2 GLR at 250 or 650?
Oh, 650.
All right.
650. Lord, this is what this court said. It said, it has been known, indeed, it's on page 5 of 15 of our statement of case. It says, it has been known for rulings in interim injunctions to be changed in the course of the same case, when the change is warranted by changed circumstances or on the occurrence of new matters. For example, a refusal to grant an application at one stage may, on repeat application, specifying changed circumstances or new matters, especially as to balance of hardship, be reversed and application granted, unquote. Lady, we move on to the second point canvassed by the first respondent. And it is that the President has expressed an unwillingness to assent to the bill. My Lords, nothing is further away from the truth than this. The statement of the Secretary to the President, as captured in Exhibit 2 of the first respondent's affidavit in opposition, is to the effect that the President will not take any steps in respect of the bill until the injunction application is determined, so as not to undermine the authority of this court and prejudice the application. Lords, the relevant portion of the statement is as follows, and it's paragraph 3, line 7 of the letter signed by the Secretary to the President. And it reads, indeed, it is settled law that during the pendency of an interlocutory injunction application, the status quo ante ought to be preserved, and no action should be taken that will result in prejudicing the injunctive relief sought and undermining the authority of the court. Lord, this is what it says. The President or the Secretary to the President never said the President has expressed an unwillingness to assent to the bill. So that claim is factually inaccurate. Lord, thirdly, the first respondent argues that the grounds for the grant of an interlocutory injunction has not been proven by the applicant. Lord, it is our contention that we have proven all the elements for the grant of an injunction in paragraphs 33 to 75, paragraphs 33 to 75 in our statement of case in support of the injunction application.
Which elements are?
Which elements are, my Lord, relying on the case of Welfare Kwaku, is that whether there is a serious question to be tried, that is first. 2, whether the applicant will suffer irreparable damage which cannot be remedied by the award of damages. And then 3, whether the balance of convenience is in favor of granting him or her the interlocutory injunction. My Lords, also in the case of Michael Ankuma Nimfa versus Justification and others, the court reiterated these conditions for the grant of injunction. Lord, we claim, or we assert, through our statement of case in paragraph 73 to 75, that one, the applicant has a legal right. The applicant has a legal right which stems from Article 2.1 of the 1992 Constitution that must be protected. The applicant, as a citizen of Ghana, has a right to commence this present action. And indeed, Article 3.4 of the Constitution also imposes an obligation on all citizens, including the applicant, to defend the Constitution. Lord, again, the case of the applicant is not frivolous. The case of the applicant is not frivolous. The applicant is alleging an egregious breach of Article 108 of the 1992 Constitution, which is a matter of public interest that affects all Ghanaians. An alleged violation of the Constitution by the officers sworn to protect it. It's not a frivolous matter, but a matter of utmost importance to protect the sanctity of the Constitution, our democracy, and the respect for rule of law. Lord, again, the respondents will not suffer any hardship if the injunction application is granted. As any inconvenience that may suffer, they may suffer, is not personal. Lord, we rely on the case of Ghana Independent Broadcasters Association versus the Attorney General and the National Media Commission. And my lords, it's reported as 2017-2021 Supreme Court of Ghana Law Report 498. My lords, it's our contention that the respondents will not suffer any hardship if the injunction application is granted. But on the other hand, if this application is refused, the applicant and every citizen of Ghana will continue to endure a flagrant and blatant violation of the 1992 Constitution, and the court cannot shut its eyes to such violation. But again, we contend that irreparable harm will be caused to all Ghanaians by the refusal of this injunction application. Assuming the bill becomes law. My lord, indeed, even on 28 February 2024, when the bill was passed, people thought it had become law, and some members of a certain community suffered violence. My lord, this is a bill that attempts to take away rights of citizens. This is a bill that also imposes a charge on the public purse. My lord, even the pre-trial matters, if this occurs, my lord, the dignity of the Constitution, as well as the dignity of the individuals who may suffer arrest and detention, can never be fully compensated by any damages, the award of damages.
I think you're forgetting that what you are seeking to injunct is a transmission to the president. The bill will not become law unless the president signs. So that's what you should be addressing. Why should this court interfere with the proceedings between Parliament and the presidency before the bill becomes law?
Lord, we think that this court must intervene because this is a constitutional democracy. We have moved from an era of obey before complain to an era of justification. If any public institution, any public official has to do anything, the person must justify their actions within the Constitution. Now, the Constitution says, you shall not proceed with a bill that is introduced by private members. We have endured this for a while. This is a flagrant violation of Article 108 of the Constitution. We have endured this for a while, even though this writ has been pending in this court since 1st June 2023. Because we think that having gone on to consider the bill, finalize it, even in spite of the advice, even by the second respondent, it is about time that someone steps in. And it is this court that can do that job, to step in, to stop the transmission of the bill until the final determination of this matter. Lord, we have already argued that the matters raised.
Counsel, why can't you trust the president to exercise his powers under the Constitution?
Well, that's a very good thing to say. And we agree with that the president will assert his rights under the Constitution. But once there have been a violation of the Constitution, and clearly the wording of Article 108 says that somebody...
Isn't that part of the duties of a president?
Well, Lord, it has not moved to the duty of the president yet. We are still in Parliament. And we are saying that once a violation has occurred, and the Constitution says somebody should raise their hand, and the plaintiff applicant has raised their hand.
When Parliament has passed a bill,
yes,
has it not finished its work? Doesn't it move to the next stage where the Constitution prescribes what must be done?
My lady, the bill shouldn't have reached this stage in the first place, but it has reached this stage. Assuming it goes to the president, and the president refuses to assent, it comes last with Parliament. And in that case, Parliament can go ahead to pass it. They have the requisite numbers.
But the Constitution has laid down a procedure to be followed. Why can't you trust the process to follow through, and if the results are not to your taste, then you can come and complain?
Yes, my Lord, that's also a valid argument to make. But this is the only, I will venture to say, the only article in this Constitution, Article 108, that says that a bill can be challenged even before it becomes law. Article 108, by the wording, shows clearly that this is the only one, and this is the first time this court is hearing this matter. And we think that a hand has been raised, and the court should listen to the hand that has been raised. Because if all things being equal, if the right processes, this is not a mundane parliamentary procedure that has been flawed. This is a constitutional violation, because the Constitution says don't proceed, and you have proceeded. And so even the cost associated with considering this bill.
Counsel,
yes,
it is a very important matter you are addressing. That's why I want you not to overlook certain things. Yes, 108 talks about some limitations. It also talks about, in the opinion of the person presiding. Why don't you address those matters so that they show clearly what should have been done and wasn't done? Sometimes I've been trying to listen and follow and trying to draw your attention to the fact that don't skip important aspects of the argument.
The professor is speaking.
Yes, my lady. My Prof, Lady Justice.
The professor in here is itching.
Prof, Lady Justice. Yes. My lords, the point we are making is this, that Section 101 of Act 921, as well as Article 108, a combined reading of the Constitution and the legislation, clearly suggests that at the time a private member introduces a bill, there must be a financial impact analysis. And a financial impact analysis should show that this is the cost the state is going to bear. If there is no cost associated with the bill, then it goes through, and nobody has a problem. But if there is a cost associated with the bill, that is where the bill must stop.
Now, what will be the cost associated with this bill?
Lady, clearly,
where will the cost come from?
The cost will be when the pre-trial matters are triggered. For instance, arrest. It will involve the state's coercive forces to arrest people. A lot of detention. People will be kept in detention, they have to be fed. If they are sick, they have to go to the hospital. My lords, the bill even imposes a duty on all citizens, the judiciary, the legislature. That requires some resources to actualize this. Even when people are supposed to go undergo so-called conversion therapy, they all require resources of the state to be spent. I mean, Lord, we are all painfully aware of the conditions in our prisons. The prisons are overcrowded. People don't have 3 square meals in a day. They are not able to attend clinic and all that. And we are going to add more people. And it even moves beyond them. It's not even going to affect academia. I'm an academic, I teach, and from the wording of the bill, I cannot go to class and talk about human rights and discuss the rights of LGBT because I could be arrested as well.
Counsel, I think that is the substantive case. At this stage, the question my sister is trying to ask you is, why should we injunct an institution? You know, the gravamen of your case is based on Article 108, yeah. And then 100, Section 100 of Act 921. All right, that is the gravamen of your case. We haven't gotten there yet. So the question is, why should we injunct an institution which is an arm of government that we've given a mandate to do certain things? That's yeah. So at this stage, why should we injunct them? I think that's what
Council. So we have 3 arms of government working here. All are required to be independent, to be able to take their decisions independently. So Parliament has taken its decision. You have a problem with that decision. You've come to the Supreme Court, which is your right under Article 2.1. You have clearly outlined that. But you are asking the Supreme Court to stop a communication between Parliament and the executive. And if you recall, my sister to my left asked, why can't the executive be allowed to take its own decisions on this matter? Yeah. And if they take the wrong decisions that violate the Constitution as you allege, then it will be the duty of the Supreme Court to correct it.
Lady, our simple answer is that the violation has already occurred. The violation of the Constitution has already occurred. And some may choose to wait, but the plaintiff decided that we cannot wait to endure any further breaches of the law.
So we don't have any problem with you on that.
Yeah.
You know, you are here to challenge whether the bill, so far as you are concerned, you know, went through the proper processes. And your trump card is Article 108. And then Section 100 of Act 92. We are here. That is the main, you know, course of action. That's why you are before us. But in the interim, you want us to injunct, you know, an arm of government, and that's where we have a little bit of a problem.
We want you to address us on that specific question. In what you see, you make the point that there's been a violation of the Constitution. That's your submission. Are you presenting that whenever there's a violation of the Constitution, the jurisdiction of the Supreme Court is so invoked that the Supreme Court cannot exercise its discretion to restrain itself to see whether that violation will continue or it will not continue. Don't forget that there has not been a determination of whether there's been a violation or not. That's your position.
Yes.
Or you think you've addressed us enough?
Milady, I think I've done my bit, but I still get the point you're making. And the point, maybe I'll add to it to see if I meet your expectations. The point is that the Constitution gave birth to Parliament. It gives it powers. It says do A, B, C, D. Don't do E, F, G. And then they overstep their bound to do what the Constitution says don't do. Now we are saying that if what they have been asked by the Constitution and a constitutional supremacy that don't do, if they do, the impugned act, if the bill becomes law, assuming all things being equal, it is signed, it becomes law, the damage or the harm, the indignity that the Constitution will suffer, the indignity that the plaintiff and citizens of Ghana will suffer can never be compensated.
This is on the irreparable damage.
Irreparable damage. So the damage that will be caused is so irreparable. But meanwhile, the bill has been on ice since 28th February. A few more weeks, a few more months, and they will not suffer any damage personally. Indeed, there are other bills, other laws that have been proposed that give rights to citizens. Affirmative action bills, spousal rights bills.
Very well, very well. I think your point is taken. Since you haven't added to what you said, clearly we should just take what you have given. Do you have any more points, or should we move on to another?
Well, maybe I'll add that the remedy, if there's a violation of the Constitution, does not lie with the President, but it lies with this court. And so therefore, we shouldn't wait for the President to remedy a violation. It is for the courts to do so. And so that is the small point I will add to that. And my lords, finally, in addressing Thus, finally, we want to...
You need to be rounding up.
Yes, my lords. Thus, finally, the first respondent purports to have attached...
You mean Parliament?
Parliament, yes. Purports to have attached a fiscal impact analysis which was conducted in respect of the bill to the supplementary affidavit. Yes, as exhibit... my Lord, will refer you to Exhibit 4 of their supplementary affidavit, which was filed. Okay, my Lord, we'll first go to the affidavit in opposition filed by the first respondent on 20th May 2024. Lord, Exhibit 4. It's Exhibit 4. Lord, they claim to have attached the fiscal impact analysis that was conducted in respect of this bill. But my Lord, if we look at the exhibit, it is rather an extract of the Public Financial Management Regulations 2019, LI 2378. My lords will also recall that the first respondent's supplementary affidavit filed without leave of this court on 30th April 2024. They also purported to have attached a fiscal impact analysis. Again, they did not attach it, but rather attached the same exhibit in this one.
The extract from the law.
The extract from the law.
The bare provisions of the law.
Yes, the bare provisions of the law, without more, my lady. Lord, it's our contention that clearly the fiscal impact analysis has not been conducted, since on all these two occasions, They purported to have attached the fiscal impact analysis, but it turns out that they have not done so. My Lord, the second and most important point in relation to this is that this averment that the fiscal impact analysis has been conducted is inconsistent with all the previous processes filed before this court by all parties, including the first respondent's amended statement of case filed on 14th March 2024. Their claim that they have done the fiscal impact analysis is inconsistent. It's inconsistent with their amended statement of case filed on 14th March 2024. Lords, I will respectfully refer you to paragraph 20, Roman numeral 2.
Please read it. Please read it.
Yes, it's under the heading Admitted Facts. And it says, the first defendant agrees that the bill was presented to Parliament on 29 June 2021 as a private member's bill. 2, the bill was not accompanied by a fiscal impact analysis nor a document detailing the financial implications in respect of public funds as a result of the bill at the time it was first laid in Parliament. 3, first defendant nevertheless referred the bill to the committee for deliberations without an opinion as to whether or not the bill imposes a financial burden on the state. 4, chairman of the committee wrote a letter to the second defendant.
You refer to an affidavit of 14th March.
That is, yes, we first refer to an affidavit of 30th April.
No.
What I'm reading now,
yes,
it's 14th March 2024.
14th March?
It's the first defendant's amended statement of case.
Oh, you said affidavit?
I'm so sorry.
But I thought initially you complained that he had not filed any statement of case.
Yes.
When you started your submission.
Lord, this is for the substantive case,
Okay.
not the injunction application.
Looking for an affidavit.
Lord, it's page 5 of 43.
We have an affidavit filed on 22nd March.
You are referring to a statement of case filed in support of a substantive suit. Isn't that the case?
Yes, my Lord, we refer to 3 documents. So the
No,
first,
what you are reading.
what I'm reading now,
Yes.
is the first defendant's amended statement of case filed on 14th March 2024 at 12:10 p.m.
You refer to an affidavit.
Lord, the affidavit I refer to is the current one, which is opposing our application for injunction.
The difficulty we are having is that the record of the substantive matter
It's not.
is not before us. What is before us is the record of the application. And so we don't have the affidavit you are referring to.
Yeah.
The statement of case you are referring to.
Very good.
You can round up.
Yes.
You're taking up quite a bit of time.
Lady, so it is our prayer that our injunction application respectfully be granted, and we pray accordingly.
So sorry. What I was thinking is that we listen to both sides since they are both attacking you. The application is against you. Yes, so we listen to the Attorney General as well.
Most grateful.
And then you are the principal respondent. So you respond there. Thank you very much.
Leadership, I'm grateful. The court would note that we have, in a very unconventional manner, not explicitly indicated whether we oppose to the application or not. That is very much consistent with my philosophy that in matters of this nature, in constitutional actions, the court's duty is to settle questions, to settle important questions of law that arise, and not necessarily decide cases. The distinction has to be made between the court's exercise in settling a question rather than deciding the case. And this is one important matter that, with all respect, I submit that the court ought to settle very fundamental questions that arise in the plaintiff's action. And therefore, the interest of the Attorney General, with all respect, is not necessarily to state a position in favor of one party or not. Because the issues that arise in this matter, for me, go beyond the interests of a specific party and rather impinge on how the provisions of the Constitution, insofar as the exercise of legislative power by Parliament with regards to financial matters, ought to be done. Especially, indeed, the application before you is an application for interlocutory injunction. And I recognize that the plaintiff's main basis are three. The plaintiff's main basis for the instant action are three. Firstly, the plaintiff's action seeks to question the power of the Speaker in admitting for consideration by Parliament the bill that has been described as the Human and Sexual Family Values Bill of 2024, a copy of which has been annexed to the plaintiff's application. Secondly, the plaintiff raises issues which allege violations of some provisions of the Fundamental Human Rights Chapter of the Constitution, Chapter 25. Then also the plaintiff...
Chapter 5.
Chapter 5, I'm sorry. Chapter 5, I'm sorry. Chapter 5. Then also the plaintiff questions... I think that is it. It's only which is carried out. It's a third basis. So those are the two main bases. And my lords, for me, the main basis for the grant of an interlocutory injunction in the constitutional case is whether substantial questions of law have been raised. The court may also proceed to consider the justness or convenience in granting an interlocutory injunction. Indeed, I've examined the court's exercise in this regard since 1996, and I note that in certain constitutional cases, a few of them, it must be stated, a few of them, injunctions are granted. I refer to a qualm against PNM number 1, reported in 1996-97 Supreme Court of Ghana Law Report, at page 117, in which the court granted an injunction in a constitutional action. I will, in the course of the submissions, also examine other decisions of the court in which injunctions or injunction applications were denied. So the court would note that we have set out three main issues that have to be considered by the court in adjudicating on the plaintiff's application. The first issue, with all respect, is whether or not the passage of the Human Sexual Rights and Family Values Bill 2024 by Parliament on 28 February 2024, prima facie, constitutes an act under Article 2, Clause 1, Paragraph B of the Constitution, so as to vest in the plaintiff, a citizen of Ghana, a course of action. The second issue is whether or not prima facie a contravention of Article 108 of the Constitution is disclosed in the processes leading to the passage of the Human and Sexual Rights and Family Values Bill 2024 passed by Parliament. And then the second one is whether or not prima facie a contravention of Article 108 of the Constitution is disclosed in the processes leading to the passage of the Human Sexual Rights and Family Values Bill 2024 passed by Parliament. The third issue is whether or not the plaintiff's action prima facie discloses real allegations of violations of the provisions of the Constitution of fundamental human rights. Especially, I would seek leave of the court to address the second issue, which I indicated as having been raised by us, because I consider that issue very fundamental.
Indeed, the plaintiff applicants dwelt extensively on that.
Yes, precisely. But that issue centers around an allegation of a contravention of Article 108 of the Constitution. Respectfully, 108 of the Constitution, I know has been read by the plaintiff, but if I may, just for the avoidance of doubt and for the sake of emphasis, quote saying, I leave for the court, I proceed. Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President, A, proceed upon a bill, including an amendment to a bill that, in the opinion of the person presiding, makes provision for any of the following: Roman numeral I or 1, the imposition of taxation or the alteration of taxation, otherwise than by reduction, or Roman 2, the imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction, or Roman 3, the payment, issue or withdrawal from the consolidated fund or other public funds of Ghana of any money is not charged on the consolidated fund, or any increase in the amount of that payment, issue or withdrawal. Indeed, I would like to rest here because those three for me are the most important for the purpose of this exercise. And the points I note from Article 108 is that, first, the conditional phrase in paragraph A. First, the conditional phrase in the commencement of the provision itself. Parliament shall not, unless the bill is introduced. The conditional phrase indicated there actually restricts the power of Parliament to exercise its legislative authority vested in it by Article 93, Clause 1 of the Constitution. Article 93, Clause 2 of the Constitution. And I say that the conditional phrase restricts it because, indeed, the provision itself proceeds to set out the specific matters that Parliament is prohibited from considering, insofar as those matters come within the premises of Article 108. And those are: 1, a bill that, in the opinion of the person presiding, makes provisions for One, the imposition of taxation or alteration of taxation, otherwise than by reduction. So insofar as there's any bill which has the effect of imposing taxation or reducing taxation or alteration, imposing taxation or altering taxation other than by reduction, then it shall come under Article 108. Secondly, most importantly for this exercise, the imposition of a charge on the constituted fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction. Indeed, the Constitution does not define charge. But my lady, clearly, the ordinary meaning of a charge on the constituted fund is a burden being placed on the constituted fund. So far as there's a burden being placed on the public purse of Ghana, that's the constituted fund, then clearly such a matter must come within the specific details of Article 108. And then Roman 3 of paragraph A of Article 108 says the payment, issue, or withdrawal from the constituted fund or other public funds of Ghana of any money is not charged on the constituted fund, or any increase in the amount of that payment, issue, or withdrawal. Again, insofar as there's a payment, issue, or withdrawal, or a bill which has the consequence of ensuring a payment, issue, or withdrawal from the bill, clearly there must be, from the fund, constituted fund, clearly there must be recourse to Article 108 of the Constitution. Indeed, yes.
The 108A1 that you read, the one about otherwise than by reduction.
Right.
I'm trying to think of a situation where a bill could reduce taxes without affecting the income or revenue of the state. So I'm looking at how one can be achieved, Roman 1 can be achieved, for example, which does not violate Roman 2.
True. Yes. I think that's a very good observation, especially. And I would say that that is actually the basis for a holistic interpretation of the Constitution. So in construing the Constitution, it did not indeed look at it narrowly. And if indeed the court were to adopt such a constructive approach to interpretation of statutes, which is by looking at the statute as a whole, I would say, with all respect, that indeed, having regard to the, or by virtue of the combined effect of Roman 1 and 2, even such a bill must be caught within the demands of Article 108. That is a bill which is effectively reduces taxation. An argument can be made that indeed, to the extent that such a bill results in the reduction of the public purse, it must come within the premise of Article 108. So indeed, I agree with the court of the observation of my lady. My lady, I make the further point that indeed, Article 108 seeks to place the prerogative of the determination as to whether a matter comes within the premises of Article 108 on the Speaker, the person presiding in Parliament. It may not necessarily be the Speaker of Parliament. It may even be another member of Parliament who has been mandated to preside over proceedings. Yes, but that is where.
What does on the person presiding
mean?
What would that mean in law?
In law, but it means a person. It means first and foremost the Speaker of Parliament, or in his absence, a Deputy Speaker, or in the absence of a Deputy Speaker, a person who has been mandated to preside over proceedings of Parliament. Because indeed, if the court were to look at Article.
Yes, and yes. Also, in order not to spend much time on that, what does in the opinion also mean in law? Yes. What would that require?
Right. So maybe 2 points. First and foremost, the determination, in the opinion of the person presiding, means as per the determination of the person presiding. But secondly, and more importantly, that determination must be subject to the Constitution. Because finally, the exercise of any discretion whatsoever under the Constitution is not unconstrained.
It's not?
Unconstrained. It's not unconstrained. It means it is constrained. And it is constrained by the Constitution. And if there's a dispute, it is subject to the determination of the Supreme Court. The Supreme Court's jurisdiction can be properly invoked to determine whether a person's discretion conferred by the Constitution has been properly exercised in accordance with the dictates or the demands of the provision of the Constitution by which the person is supposed to go by which the person is supposed to go. Now, my lady, indeed, this proposition is not novel. It is one that has been amply established by the court in numerous authorities. I can refer with all respect to J.H. Mensah against the Attorney General, reported in the Supreme Court of Ghana law report.
You mean the proposition regarding discretion?
No, proposition regarding even, specifically even in relation to Parliament. Mm-hmm. That even Parliament, the conduct of parliamentary proceedings and powers imposed on Parliament
are all subject to the Supreme Court. Subject
to the Constitution itself. So J.H. Mensah and Attorney General established that in reported 1996, 97 Supreme Court of Ghana law report. Mm-hmm. At page 320, it had earlier on been firmly established in before an Attorney General, 1980 Supreme Court of Ghana report. Especially, quite recently, even the Abu Ramadan line of cases, the court asserted that even in relation to the Electoral Commission, which has absolute independence in the conduct of elections and the making of regulations, even the regulations that the Electoral Commission comes up with, subject to the determination by the Supreme Court as to whether it is compliant with the Constitution or not. So I did a firm point by the established that the opinion of the person presiding in Parliament does not confer on that person an unconstrained discretion. And
in order to focus, I would like to remind you of the submission by counsel for appellant that applicant, that in his view, there's been a contravention of Article 108.
Right.
And that very occurrence provokes the jurisdiction of this court. And that very occurrence must provoke the invocation, the issue of an injunction.
Right.
If you could address that.
Yes, I'll quickly address that. But if I may quickly also refer to a point that we raised in a civil case that we filed in the Fiscal matter. But in this matter, I didn't file a civil case because the court had not ordered for us to file so. But that point is that indeed, if the court were to look at all the constitutions this country has had since independence, the court would note that a provision in the nature of Article 108 has been present in every constitution, apart from the 19th Constitution, which of course made the president a lifetime president. So from the 1957, even the Independence Constitution, and the provision was replicated, and that was in Article 41 of the 1957 Constitution. And specifically, if I may quickly read, Clause 2 of Article 41 says, except with the recommendation, Clause 2 of Article 41 of the 1957 Constitution, that except with the recommendation or consent of the Governor General signified thereto, the Assembly shall not proceed upon any bill, motion, or petition which the opinion of the Speaker or a member presiding will dispose of or charge the constituted fund or other public funds of Ghana, or revoke or alter any disposition thereof, and thereon, or impose, alter, or repeal any rate, tax, or duty. The same, especially in the 1969 Constitution. Indeed, provisions of the nature as the 1992 Constitution were first introduced. In 1969, it was in Article 85 of the 1969 Constitution, and it stipulates as follows, permission if I may read. It said the National Assembly shall not, unless the bill is introduced, or the motion is introduced by a minister, A, proceed upon any bill, including any amendment to a bill, that in the opinion of the person presiding makes provision for any of the following, that is to say, that it lists all the factors there, the imposition of taxation or the alteration of taxation otherwise than by reduction, and then similar provisions also there. Same is also found in the 1979 Constitution. But the point I seek to make out of this,
just to provide some assistance, in the 79 Constitution, the parallel provision is Article.
It is Article. It's Article 90 of the 1979 Constitution. Article 90.
Yes.
But the point I seek to make from all of this is that, indeed, these financial provisions are so important to the nation that the Constitution has deliberately sought to insert them. And the Constitution, in its deliberate framework, once again, seeks to centralize the management of the public purse. And for that matter, the imposition of any charge on the public purse or a withdrawal from the public purse must be done strictly pursuant to the initiative of the executive. I made this proposition not because I'm a member of the executive, but because by virtue of Article 88 of the Constitution, I'm the principal legal advisor to the government, and as the courts have held from time immemorial, the Attorney General is a protector of the public interest. And therefore, it matters that border on the public interest, the public purse and all, I take a keen interest in. Especially, I say that, indeed, the court, in my respectful view, the bill as presently constituted, and I've taken time to set it out in the other matter, it is the same bill, for that matter, I'll quickly refer to the particular provisions that I alluded to there. The bill, by virtue of certain provisions, really seek to impose a burden on the constituted fund. And it is not a position I took after the instant action was filed. Indeed, it is a position I expressed in my opinion to Parliament during its deliberative processes on the bill. I've attached a copy of my opinion to Parliament as Exhibit AG. And respectfully, I allude to clauses.
AG.
Yes.
AG, when...
Yes. I'm sorry, my lady. Sorry.
When you were talking about the importance of the discretion and so on, and how the Constitution controls it, I hoped you would go beyond it to show how it should be signified, right, for it to be ascertainable.
Right.
But
that the discretion is constrained.
You said discretion, so how is it to be signified?
How is it to be exercised?
Yes. Right. But I think first and foremost is signified through the manner in which the particular provision has been formulated. Now, my lady, in respect of this particular case, the court would note that, as I indicated earlier on, that there is a specific prohibition on Parliament itself from proceeding. And then also, there is also an indication of certain factors that will have to be considered by the person presiding. So the factors to circumscribe the exercise of that discretion are spelled out clearly in the provision itself. That is Article 108.
No, AG, I think that's what my lady was asking, if I'm not mistaken, is the opinion that has to be expressed by the person presiding. How is it expressed? Is it orally, so that it can be ascertainable?
Right.
So does the person say, I have read everything, and in my opinion, it goes into the Hansard, or as submitted by counsel for applicants, it should be signified or expressed by the accompaniment of the fiscal analysis. That was his submission. Or, in your opinion, there's another way?
I would say that those two factors are important, and perhaps I'll add the third one. But the first and foremost, there must be an ascertainable exercise of that discretion. That discretion should be ascertainable that it has been exercised. So there must be a specific determination. That is why I found it a little bit worrying, with all respect, that there seems to be an omission of a determination by the Speaker attached to the Speaker of Parliament's processes. Indeed, the court will know that traditionally I would have raised an objection even to the Speaker of Parliament being a proper party to this action. But I deliberately did not raise an objection because I felt that the matters are so important, such that the view of the Speaker of Parliament perhaps may not be consistent with that of the Attorney General, and for that matter, he ought to be a party. And I felt that if indeed that the Speaker of Parliament is made a party, has been allowed to be a party to this action, and the Speaker of Parliament then contends that he exercised his discretion and actually made a determination that the bill fell outside the premise of Article 108, there must be an exhibition of the exercise of that discretion. So in essence, there must be, if it were a court, there must be the ruling attached. In this case, there must be a proceedings or perhaps an extract from the Hansard of the proceedings by which the Speaker of Parliament made that determination. That is the first step. The second step is that the Speaker of Parliament, it being an exercise of discretion under the Constitution, would have been bound by Article 296 to rationalize why such a determination was made. There must be a reasoned ruling, a reasoned determination to assist not only the court but the entire nation as to why such a determination was made.
So, AG, you will not accept. Sorry.
Yes, sir. Yes, sir.
And
So you will not accept quote and unquote determination by conduct, that the fact that the person presiding allows it to proceed is an indication that the person's opinion is that it conforms to whatever.
No, but that would be very much unhelpful.
It will not be. I just wanted you to say something categorical.
Right. Yes, but it will not be helpful because then it denies an assessment as to the reasonableness or otherwise, or indeed even the propriety of the exercise of that discretion. Then also a third factor is that the Public Financial Management Act, as has been alluded to by the Attorney General, in fact, I stated it even in my opinion to Parliament, has sought to bolster Article 108 by requiring that any bill must be accompanied by financial analysis. Because indeed, again, I say it bolsters because it reinforces the contention I'm making that there is a centralized process for management of public funds. And therefore, where there's any charge at all on the public funds, there must be a demonstration of how it affects the public funds or the extent to which it affects the public funds. And if there's also an allegation that the bill is no burden or no constraint on the public funds, there must be that analysis. And that is set out in the financial analysis required by the Public Financial Management Act.
Attorney General, what I am picking up from this morning's submissions and from the processes before us is that not only has the Constitution provided that there must be a determination in the opinion of the person presiding, but the Constitution has gone on through the statute to set out how to assist with how that determination ought to be made.
Precisely. Made. The fact is.
So I have understood you.
Yes, please. The fact is that's indeed, I'll quickly move on to why certain circumstances the court do not really grant an injunction in the constitutional case. And the reasons are not far-fetched. Right.
You go on, Honorable Attorney General. If I understand what the position you are taking, your position clearly is that this bill imposes a burden on the consolidated fund.
Yes,
that's your clear position.
Yes,
I believe that's the position of the applicant as well. And I also believe that the position of the first defendant is that it does not constitute, if you read his...
yes.
So now we sitting here, would you...
What you said, it does not constitute...
It does a charge on the consolidated fund.
I don't think that's... Well, he can speak for himself.
Oh, okay. So maybe I'll reserve my question for that. But in my mind, I'll reserve my question after he has, yes, so that I will articulate my points. Okay, thank you. I can proceed.
So, indeed, to assist the court, I refer the court to clause 2 of the bill, which places a collective responsibility on all organs of state, including even the judiciary and state institutions, to promote the values enshrined in the bill. Nebulous as promotion of the values of the bill is the concept, and we pointed it out in our original opinion, was still not corrected. That how is a state institution required to promote the values of the bill? Is it through education? If it is through education, it is still a constraint on the public purse. So promotion of the values of the bill required of all organs of state and state institutions will involve a charge on the considered fund. B, the criminalization of various acts. Clearly, an enforcement of which will require the work of investigative bodies and security agencies of state in various provisions of the bill. It's not cheap at all to prosecute. It is not cheap at all to criminalize actions and to prosecute. It may seem to be free, but it's not free at all. It's actually a heavy burden placed on the considered fund. Then the provision of prison facilities, which will be a consequence of clauses 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 14 of the bill. No doubt will require a charge on the considered fund. Again, there is also a duty placed, I would say a power which has been conferred on the minister responsible for culture in consultation with the ministers responsible for health and gender and children and social protection to make regulations under the bill to regulate various matters provided by the law. It may seem to be an act that is exercised in respect of other laws, making of regulations by ministers. But the point is that hitherto, until recently, there was no such thing as private members' bill. So indeed, there was no such requirement.
This is the question I wanted to ask all of you, but I thought I would hold on till I had heard from Parliament whether in our constitutional histories from First Republic to Fourth Republic we have had a private members' bill such as this.
Right. Especially, indeed, the situation is novel, and it occurred only in the life of the 7th Parliament, which was from 2017 to 2021. It was in that time that the Speaker, the former...
In the very last Parliament.
The very last Parliament. Yes, that's the Speaker of Parliament, then Professor Michael Quay, quite innovatively encouraged the initiation of private members' bill, and it was the first private members' bill. It did not involve any charge of reserve fund at all.
Which was?
I forgot the time matter. I think it was not a very controversial subject matter, and for that matter, it didn't really. But there was one such bill. I believe the Council for the Affairs for that may assist the court in that regard. But the first bill was introduced in Professor Michael Quay's tenure as Speaker of Parliament. I think 2019 or so. And especially so, hitherto there was no such concern as to the implications of a bill for Article 108, because all bills emanated from the executive. So there was implied in the introduction of such a bill a consideration of the financial implications. And indeed, there was no concern, because the basis for the Speaker to exercise, or the person presiding to make a determination, did not arise, because it was from the executive. But that is why I consider this point so important, that I think the court ought to be given an opportunity of determining the issue, whether indeed there has been an infraction of Article 108 or not. Because from 1957, the provision has been present in every constitution the country has had, apart from the 1961. And the 1960 was quite peculiar, as you said. It gave somebody a life president's status. So that's quite different. And if such a question has not been determined by the court, I think with all respect, the court has to be given an opportunity. And my preference, I would say, would be for the court to preserve the status quo, determine the question, and then if the determination is made, whichever way, then the nation can move on.
Determine which question? Determine the question in the substantive suit? No. Or determine the question in this application?
No, determine the questions in the substantive suit.
The substantive suit.
So pending that, then there ought to be a preservation of the status quo for the court to give an opportunity of determining. So this then also ties in with my examination of certain cases in which the Supreme Court has refused an injunction. And I'll first start with Wilford Kwaku against the Attorney General, reported in 2012, Volume 1, Supreme Court of Ghana report, at page 259. It is the Supreme Court, considered by a single justice of the court, Justice Datiba, declined to grant an injunction. Because, respectfully, it was an action that related to a move to halt the creation of electoral districts under the Local Government Act. So, that was a peculiar case. There was the creation of electoral districts by the Electoral Commission, and indeed, the application was filed only or determined only in June 2012, 6 months before the election. It will have had an effect on the election, prior to the election. The court, in its wisdom, actually stated, held at page 25260, that in the interest of the public, the collective interest of the public, said that where the relief sought release as here to a public law matter, particular care must be taken not to halt the action presumptively for the public good. The action was for the public good, and therefore the court declined it. But the second case occurred in the same 2012, and that is Ransom France. Ransom France, number 1, against the Electoral Commission and Attorney General, was filed in July, I think it was filed in August 2012 by my good self. And the court determined it in September 2012. The court would note, clearly, it involved the Electoral Commission. It sought to restrain the Electoral Commission from laying before Parliament regulations that had enacted for the conduct of the 2012 elections, 3 months before the elections. And for that matter, the court dismissed my application for interlocutory injunction. I was not peeved at all. I moved on with my life. So clearly, it is only where the court considers the collective good of the nation. And I would say that in matters that border on withdrawals from the constituted fund or the use of the public purse, as I have with all respect demonstrated before you, the collective good actually will be in respect of holding a status quo for the court to indeed determine whether the bill that is being sought to be, for want of better expression, rushed is in the public good or indeed affects the public purse. If the bill affects the public purse, then with all respect, the court owes a duty to halt the progress of that bill. I would also quickly address the point that this is actually not a case where the law in question is at its formative stages or going through the processes in Parliament. Indeed, all the processes in Parliament have been completed. Parliament effectively has concluded the processes. And indeed, now, if what is supposed to be transmitted to the President will actually be titled an act, it is just to the signature of the President and then to become law. And I would say that, having regard to the completion of the processes in Parliament, what Parliament has done will constitute an act under Article 2, Clause 1, Paragraph B of the Constitution. That is an act, a small act, not the act with a capital A, Act of Parliament. It is an act with a small a, which is an action or a decision.
And so your presentation or your submission is that the jurisdiction of this court has been properly invoked?
Yes, as
for this application or for the substantive action?
Pardon me? For
this application or for the substantive action?
Oh, I'm only saying so because of the requirement in injunctions to show the existence of prima facie case as well as a substantial important question of law.
I think, can you clarify that point? I think I missed it. You are saying that Parliament has completed its processes, its procedures, and that what they are seeking to do is an act that's beyond its proceedings.
No,
but
I'm saying that now we can actually find an act having been committed. And the act has been committed, in fact, two acts. First is the opinion of the person presiding, which in itself will constitute an act. The determination by the person presiding will constitute an act by the person, not an act of Parliament. So once there is that act committed, it can be basis for the invocation of the court's original jurisdiction. Secondly, the completion of the processes in Parliament pursuant to the exercise of that discretion by the person presiding by Parliament will also constitute an act that can be brought within the premises of Article 2, Clause 1, Paragraph B. And indeed, I just want to have to emphasize that it's not an act of Parliament I'm referring to. It's an act as in a decision or a step by a person.
To help all of us, I think that I want to read 2(1)(a). A person who alleges that any act or omission of any person is inconsistent with. This is what you mean. Attorney General?
Yes, Mr.
Any act or omission.
Yes, Mr.
And your submission is that there is an act.
As in an action by a person, yes.
And there are two acts actually.
Yes.
This is your submission.
Yes,
the first act is the determination by the person presiding. And the second act is the completion of the proceedings.
Processes in Parliament. Respectfully, that's all. So I pray to rest my submissions, except as the court may have some questions. If the court has no questions, may I rest?
Standing clearly, your position is that we hold matters in abeyance to abide the outcome of the hearing of the substantive suit because of the gravity of the issues that have been raised in this application.
Yes,
that is what you are saying.
Respectfully, that's so.
Okay.
So, because it's quite new, and the court ought to be given an opportunity of efficiently determining it. Yeah, there we go.
Because this is the first time this sort of action has occurred.
Yes, respectfully, that's so. Since 1957. Indeed, even in for Kwaku and all, the questions really were not so novel. I remember even filing an action in 2011, Akutu against the Attenjura, Bafos Akutu against the Attenjura, in which I raised the propriety of the case of distress by the Minister of Local Government there. So those cases were really didn't really raise any new questions as this one.
And whether or not under Article 108 and the parallel provisions previously, there is a deliberate intention by the framers of the Constitution to centralize the management of public funds.
Respectfully. That's right.
That would be the framing of the question that you invite the Supreme Court to do.
Yes, respectfully, that's so. I will not even go into the human rights arguments. Publicly speaking, we can even contest at the High Court the human rights, which is not really for this court.
Thank you. Oh.
But AG, before you sit down, it is your case that there was no determination by the person presiding that it was going to be a charge on the consolidated fund. Don't you think that is an omission itself?
Well, especially, yes, I really recognize that if there was no such determination, then it would be an omission.
And Article 21B.
But I would be hesitant in saying so because I would say that there's no evidence of such exercise.
Thank you.
As a lawyer, I would say that there's no evidence of such an exercise. My lawyer friend asserts that there was such determination. I would say there's no evidence of such determination.
So sorry. You've heard the broad scope of all the submissions. Yes.
We are vehemently opposed to the application, including the supplemental arguments made in support of it. My lords, the first ground upon which we are opposed to it is that this application is the same application that was previously brought before this court.
I think the submission made by counsel for applicants was that there have been changed circumstances.
I will deal with it.
All right.
I'll deal with it. And my lords, we have deposed to it elaborately in two main paragraphs, actually more than that. Paragraphs 11 to 16 of our affidavit in opposition. Paragraphs 11 to 15 of our affidavit in opposition. 20 first one to leave of record, yes. That's it.
It's 11 to
15. My lord's attention is drawn specifically to paragraphs 11 and 12 of that same affidavit. In those two paragraphs, we take time to break down the arguments made in the earlier application and compare them to the present application. And we reach the conclusion that it is the same. Now, I'll deal with the additional aspect. It says that the only difference between this application and the previous one is that there has been a continuation of the legislative process, which is that it has reached a different stage. But in the previous application, our answer is simple. In the previous application also, it sought to injunct a particular stage of the legislative process. And our affidavit in opposition attaches the previous application, which merely sought to restrain Parliament from proceeding with the bill. And we say that it doesn't matter that this time you are saying that Parliament should be stopped from transmitting the bill because Parliament is still proceeding with the bill. That is the simple answer to that, this supposed new fact.
So the first time it sought to injunct Parliament from proceeding with deliberating, and this one is seeking to injunct Parliament from transmitting.
Actually,
that's the difference.
Yes, my lady, it doesn't add deliberating. It just says proceeding.
I'm evaluating.
Very well.
So I'm asking you.
Yeah, it only says proceeding, and proceedings would include deliberations as well as continuing with this duty to transmit it to the President. And so it is not a different application. In respect of that application, so in substance and everything is the same. In respect of that application, this court on the 19th of July 2003 made specific findings and held as follows. In fact, an enhanced panel of this court said, we have considered the merits of the application before us. It is our considered opinion that a prima facie case has not been made. So first of all, on the same arguments, in substance, the court made the finding that no prima facie case has been made out. The court made a further finding that no irreparable damage has been established by the plaintiff to warrant the grant of the injunction. And I'll go back to some of these facts.
Mr. Sir, before you proceed, I just want a little clarification. Yes. Are you saying that we are bound by this interlocutory decision?
You should generally be bound by it, especially that it was an enhanced panel of the court.
Is that the position of the law, that in interlocutory matters we are bound by a decision?
Well, my understanding of the position of the law is that the court is bound by its decisions on principles of law. And if the court decides that in interlocutory matters it's not bound, I will at least persuade you with it, because I don't see that distinction clearly in my reading of the Constitution.
From what you are saying, you appear to be urging us to consider ourselves bound by this decision. That is why I have a little problem.
Yeah, maybe let me urge.
Because if there's a principle of law that you want us to be bound by,
yes,
then please articulate that particular principle of law from this decision.
Very well.
That you think we should be bound by that principle.
I'm most grateful, my Lord. The principle of law is that the three-way tests established by this court in the so many lopsided decisions of the court in matters like this say, first of all, that you should establish a serious issues of law to be tried by the court. Secondly, you should show that
the just factor.
And then just inconvenient. Very well. And this court reiterated in the same case, on the same facts, the same principles, applying it to the facts, which are the same as now. And so if the court even decides that it's not bound by its previous decisions, delivered by an enhanced panel in interlocutory matters, I will urge it on the court that there is nothing new in this case that will justify that departure. I'm most grateful for giving me the opportunity to clarify this matter.
But Mr. Sorry, at that time, Parliament had not completed its work.
At this time, Parliament has not completed its work. Parliament's work includes, after the last full debate under Article 106, to transmit it. That's part of its work, statutorily and constitutionally.
So is Parliament able to return this bill for debate, further
Absolutely.
debate?
I was going to make that point. And some of the questions that came from the court earlier hinted at that. That when Parliament sends it to the President has options. He has a discretion whether to assent to it or not. The President can return it to Parliament to take into account some of these arguments that they are making in support of their case, to reconsider the bill. The President has that power under Article 106, clause 7 and 8, then the president can even refer it to the Council of States for advice on it and tell Parliament that I have referred it to the Council of States. And so this application in the court says, no, we shouldn't even allow the president to decide whether he can engage Parliament on the very issues that his principal legal advisor could tell him that right now, tell Parliament to do this. They say he shouldn't even get there, so that he will take the advantage of his constitutional obligation.
Oh, Mr. Sorry.
Yes.
Let's be on the same page. If I understand, and I think I do, the applicant and the Attorney General.
Yes.
In fact, the Attorney General presented an enhanced position.
Yes.
The Attorney General identified, or the applicant said, that there has been a violation of the Constitution.
Yes.
It started when the deliberations started without the fiscal impact analysis.
Yes.
And that violation more or less was completed when Parliament got to the end of its work without still having the benefit of the fiscal impact analysis. And then he also pointed out that even in the submission that there had been the consideration required by Section 100 of the of Act 921, what you attached is an extract of the LI, but not a fiscal impact analysis.
Yes, ma'am. Already.
If I may complete.
Sorry.
Then the Attorney General went on to say that there were two acts within the genre of Article 21B Act. And these two acts is that one, the person presiding did not make a determination, and that determination should be made from objective indices. And the second act is that Parliament completed its deliberations, ended with a bill that's ready to transmit without the fiscal impact analysis. So the person presiding did an act or an omission or both, and Parliament itself as an institution did so. I think that that's the submissions that have been laid on the ground.
Yes, my lady. And I say it has always been the same submission. The reason why they came to this court, first of all, was that that determination was not made. That was the point that has always been made, first of all. Secondly, the argument that no determination was made was previously even made by the plaintiff in the plaintiff had in the earlier application said that by failing to expressly state and record the reasons for proceeding with the bill or otherwise, a decision had been made by that. And that, I'm sure that's the question that my lady to your left was asking, that could in other ways, could we will not accept an omission or a conduct that suggests that that decision was taken, except if we see it in writing. And I'm saying that throughout the history of parliamentary proceedings, in respect of the constitutional provisions that reflect this constitutional provision which has caused this suit, the question is whether it is always the practice for the person presiding to make that determination in writing in respect of every bill that comes to Parliament. The practice is that doesn't exist. In any event, I want to look at the rules.
Have you even stated that in your affidavit, that practice that there is for them even to have an opportunity to rebut it?
We have.
You are just spinning it out right now and from the bar, and I think that's.
I will answer that. My lord, in the plaintiff's arguments, the plaintiff strayed into the statements of case that were earlier filed, including affidavits that this court had impliedly struck out, and then even ordered me to file the present one on which we are dealing. And I'm speaking from the same statement of case. That very well. My lord said they didn't have it, but I'm responding to that point. And my lords, let me just go ahead and make this point in respect of the provision itself. It's where he made it actually. My lord said you didn't have it, but I was responding to that. The provision says this: Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President, proceed upon a bill, including amendment to a bill that, in the opinion of the person presiding, makes provision for. Throughout the submissions, I've not heard the point made about the meaning of makes provision for. The question is that the submission I'm making to the court is this: all that the person presiding is required to do is to find out whether the bill on the face of it makes provision for. That is the meaning of the rule of the constitutional provision.
So, how does it? How does it?
I'm sorry. This is how we should construe Article 108(1).
No, the submissions that we're making all said that it imposes on. It imposes. It imposes. So is their reading, and if you listen to the submissions of even the Attorney General, it is to the effect that it's likely to impose because of the following consequences. But the question is that the constitutional provision? Is that the wording of it? That is not its wording. So it is okay if they say it is likely to, or it has the effect of. That I can relate to that argument. But are we still construing the provision or saying that when the court comes to deal with the substantive matter, the court should consider reading it in a particular way to give it that effect? That is a totally different submission. And I am also submitting to the court that let a clear distinction be drawn between an act of Parliament that it is alleged has not been complied with, as distinguished from a constitutional provision that has been violated. So it is not right in invoking the court's original jurisdiction, which is to determine whether a constitutional provision has been acted in contravention of, or there has been some conduct that is inconsistent with it, to say that, oh, let's go and understand that constitutional provision by bringing provisions of a statute, which, as we speak, is being litigated by the same parties in the High Court in respect of the fiscal impact analysis under Section 100 of the Act. That matter is before the High Court as we speak.
I'm sorry, you've lost me on the points you are supposed to have made just now.
Yeah, very well.
You would have to reiterate it.
Yes, very well. So the first thing I said in relation to Article 108 is the fact that all the submissions I've heard so far don't address that key phrase, makes provision for. So does the Act make provision for? Indeed, in response to a question to the Attorney General about private members' bills being introduced, the Attorney General said he recalled one in the past. And I believe the one he recalls is the one that had to do with the Road Traffic Amendment Act. That also included provisions with the likelihood of people going to jail. It was a private members act. It was assented to, and we didn't have these issues. And so, my lords, I'm urging the court to follow its previous decision where it laid it down that presumptively, the court will not injunct this process, which has not reached a point there's nothing dire in it, because the President may exercise his various options to get what their very issues that they are articulating before the court addressed. At the very best, they should submit it to the presidency. They should not let this court arrest by way of an injunction.
But Mr. Sorry, I recall presiding over that matter. So yes, I can actually tell you what went into that decision, which is that the matter was still in Parliament.
Yes.
And whatever it is we were being asked to consider in relation to Article 108, it could be cured. It could be cured. Right now, you have completed your processes and you have a bill. Is it your submission that it can still be recalled for the purpose of curing this alleged omission?
Certainly, and that's exactly what I've been saying. So first of all, it is still in Parliament because by virtue of the pending process, the President has not accepted
That's
it.
why they're saying that. That's why they're saying that we should use our power to keep it with you until you correct what you have done.
And secondly, I'm saying that the concerns they are raising,
Do you understand?
the concerns they are raising are matters they should send to the presidency. If it gets to the presidency, the constitutional provision that requires Parliament to mandatorily at this stage not be keeping it with Parliament, but to send it to him, allows him to take into consideration their proposals and send it back to Parliament for reconsideration, and Parliament can incorporate it.
I think
that is the constitutional.
I think the point my Lady Chief Justice is making, that they are alleging a grave violation of the Constitution, in the sense that something that ought to have been done before this bill was, as it were, completed, was not done. You understand? And they are asking this court, because of that, to take a decision and restrain Parliament from proceeding to perpetuate an act which constitutes a violation of the Constitution. You are saying that they should rather take it to the presidency for whatever remedies that they can obtain there. And my lady is asking you, what if it is a matter that constitutes a grave violation of the Constitution? What prevents us, as the apex court of the land, from taking the decision on it? That is the question we want you to address.
There were three answers. First of all, there has never been anything like, our constitutional history doesn't admit of anything of like an infinitesimal violation of the Constitution. Every violation of the Constitution is grave. Two, this is an alleged grave violation. They put the tag grave violation. I'm saying that
they put the tag novel.
Well, it refined to novel, and in many instances, if not in all instances, the matters that come here are novel, because if they were interpreted, we will not become accept Article 185 or so. Was it 181? It was 5. It has come here a number of times, but the court has said that if this court has determined a matter before, don't come back here. It will be enforced by the lower court. So as for novel, grave, all of that, it is not a ground at all. It shouldn't even be canvassed in this court. As if to suggest that, some of them, we could just treat them with levity. I will get to the cases that he cited about, some involving the creation of new districts. What is happening at SAL? So there will always be these matters, and there will not be little. In any event, we say that nothing irreparable will happen if this court does not. What this court rather is invited to do is to do something that I don't think is constitutional, because it is a process that must be followed. And all of the things that they are urging on this court are capable of being decided and determined and catered for in that process as we speak. Why are they thinking that, in fact, the key question that came from the bench, which still hasn't been answered, is why don't we trust, and the Constitution has given the power to do it, why don't we trust that the President will do it? Unless there's no such allegation too. So, in every way, there's nothing new in this particular matter.
But the issue, Mr. Sorry, the issue is, do you, your client, Parliament as an institution, if Parliament as an institution agrees with them that there is a missing vital link in the considerations they should have done, why should it allow this court and allow the executive and allow the country to be expending energy on this question? If you agree with them, correct your omission. If you don't agree with them and you insist that you have done all that needs to be done, then say so. But you can't present a vacillating position that even if there is a gap, it can be fixed between the two institutions. Has there been a violation or hasn't there been a violation? If you agree there's a violation, can you go and fix your violation? If there hasn't been a violation, can you say so? So that there's a determination of that.
Very well. I think that is the point where I lost you. The submission I made to this court is that there is no violation. And I read the rule saying that, does the bill make provision for? All I hear is that it is likely to have the following impact. Does it make provision for taxation? Or does it have a provision which says
in respect of this particular matter, it should be charged on the consolidated fund. It doesn't have any such provision. All they submit to this court is that there is a likelihood that that will happen. And I'm saying there is no such violation. Indeed, I have attached to my affidavit in opposition Parliament's reaction to the Attorney General's position. The current one, the prevailing one, filed on May 20th, 2024, SB 3. And I've referred in my affidavit particularly to paragraph 7.13 at page 8. So all of his impact analysis issues he's talking about. Yes.
You are speaking about your affidavit in opposition of 20th May?
Yes, my lady.
It's made up of 7 pages.
No, my lady, there are exhibits.
Which exhibit?
There's exhibit 3.
Exhibit 3.
Yes, my lord has found it.
Yes, okay. Please go on.
Yes, so my lords realize that in paragraph 7.13, Parliament's committee notes that the committee wishes to indicate that the concerns of the Attorney General have been taken care of in the committee's proposed amendments. That is very clear. That all of the issues that the Attorney General said, he advised them on, Parliament did. The court is referred also and the court is referred also to paragraph 8.2.
Short paragraph.
No,
the 3-line paragraph is what took care of the Attorney General's concerns.
And in that paragraph, it's a well-loaded paragraph. It says it is being. My lord. It says it attaches. My lord will look at Appendix A of it. They have listed all the various amendments. And actually in paragraph 8.2 also, it says, in the light of the above constitutional imperatives, the committee decided to seek the opinion of the Attorney General and Minister of Justice on the bill. The Attorney General's concerns were duly considered. I think we should trust Parliament too. That this is a report coming from Parliament, that these concerns that are now relied on by the Attorney General.
I think I'm understanding you in this slide. You are submitting that there has been a determination by the person presiding in these clauses.
First of all, yes. Secondly, their contention based on the clear tenor of the rule cannot be correct. Thirdly, all of these matters can still be taken care of in the legislative process.
This is where I come back to my position.
No.
I have one position. No. Have you contravened? If you have contravened, do you want to go and repair? And if you haven't contravened, say so that don't push us into writing. We start here. It's 12:30. If you haven't contravened, have a firm position on that.
Yes,
then we know what to do.
That is so. Mm-hmm. And there's a report from Parliament which confirms that. And they've not spoken about it.
Sorry, I'm sorry. Let me just ask. The Honorable Attorney General was talking about a process which is ascertainable.
Yes.
You understand? Now, what can you put before this court to satisfy us, to enable us ascertain whether the constitutional duty that was imposed on the person presiding had been duly complied with? What evidence do you have in your processes?
Exhibit 3 is clear.
Which one?
Exhibit 3, the one that I've just read to you, said that it's in reference directly to what the Attorney General put before Parliament. It says that.
But Mr. Sorry.
Yes.
If you look at 7.1.3.
Yes, my lady.
The committee wishes to indicate that the concerns of the Attorney General have been taken care of in the committee's proposed amendment.
Yes, my lady.
If I have concerns and I convey them to you, should you say that you have taken care of them, so I should be satisfied.
Well,
I should be satisfied by what you have done, that my concerns have been addressed, in which case I will stop complaining.
Or you should show me what you have done, rather than tell me that you have done it.
My lady, between Parliament, which has the power to decide or to proceed in the manner in which it is proceeding, and which had no obligation to, even in terms of the legislative process, to seek the Attorney General's opinion, it sought the Attorney General's opinion and assured the Attorney General that yes, I have satisfied your position. And that's the last point between the Attorney General and Parliament.
But respect.
But if you say you have satisfied the concerns of Attorney General, how?
In
terms of their proposed amendments.
Mr. Sorry,
Yes.
respectfully, this is the bone of contention here.
As I should.
Here, the applicant said you should have attached a fiscal impact analysis to the bill. Then the Attorney General said there should have been a determination even on record. And third, within the bill, there are clear provisions that require a charge on the consolidated fund. And there has been nothing attached to show how the mathematics, the money, the cedis and the dollars are going to be determined, and that this is the requirement. Is it your suggestion that the arithmetic is not a requirement?
It is, first of all, not a requirement. It will only be a requirement if, first of all, the bill, the Attorney General had got up and read part of the bill, which showed a charge on the consolidated fund. And I've made this argument so many times, that the reading of the rule does not require what the Attorney General and the plaintiff are saying. It says if the bill makes provision for. So it would have even been a point to consider if the Attorney General had read one part of the rule to say which of them imposes a charge on the consolidated fund, in order for us to even to go into a further interrogation of this matter.
We will wait for your submissions on that in the substantive action.
Very well. And my Lord, this court made that determination in the same application that came before this court, that it will rather abide the substantive hearing of the matter in order for us to go into to these issues. So that is the first point. And I'm saying, in any event, the legislative process doesn't end with the full and final debate. It still continues. Yes, because the bill could still come back to Parliament based on all of these arguments, brilliant arguments that have been made in this court. It could still come back to Parliament. And so it will be a presumptive injunction at the moment, because the process hasn't been exhausted to where all of this cannot be done, even if they were not done. That is the point that I was making. I've always been making. That first, the provision doesn't say so. Two, assuming without conceding, Parliament still retains residual jurisdiction to deal with that. If he thinks that his opinion with Parliament says it has dealt with, has not been dealt with, he should advise the final person to refer it based on this, because he didn't take into consideration that. But at the moment, we'll be presumptively injuncting something that has no likelihood even of perhaps of becoming law whatsoever. And the questions that earlier came from the bench were quite clear.
So, Mr. Sorry, if I get you right, the legislative process comes to an end only when the president signs the bill into a law.
Yes, my Lord.
If he doesn't sign the bill into law, it's still in the process.
Absolutely. It's in the Constitution, Article 106, Clause 8. It is clearly stated that the president can decide whether to assent. He has three options: either to assent, or take it back to Parliament and say, Parliament, look at the following provisions. They impact the consolidated fund. So can you amend them? Then Parliament has an obligation to look at it. Or it could even decide that before taking it back to Parliament or sending it back to Parliament, consult the Council of States. So all of these options, the plaintiff and the first defendant, they are not satisfied. They say, oh, let's assume that that process will still not be done. Let's assume that even when I advise, as the principal legal advisor of government, when I send my arguments to him that even though I had advised Parliament, Parliament said they had done what I said they should do, but didn't do it. So tell them to go back and look at it. The position now is that let's presumptively injunct the situation. And the string of authorities that have been before this court, starting from the Welfare Kwaku to Ransford France to Haruna Idrisu,
oh, Mr. Sorry.
Yes,
Mr. Sorry. If you want to cite a case, kindly do so that we can consider it.
Oh, very well.
You know, for instance, Welford Kwaku was cited.
Yes. Ransford France was cited.
So if you want to add to the cases, do so.
There is Haruna Idrisu and two others, which even makes. Yes. It is writ number J1/9.
Is this the e-levy matter?
E-levy matter. I can cite it as such unless you give me leave.
That matter has not been settled. It's only...
No, that was an injunction application that came before the court.
Wait. All right. So you are referring to the ruling on the injunction application?
Injunction, yes. In which the court even applied the presumption of regularity. There is in the Buri number 1 versus Attorney General also. It's 2013 to 2014, 2 in the Buri number 1. (2013 to 2014) 2 Supreme Court of Ghana law reports at page 1134.
Repeat the citation. I was consulting with my predecessor. Mr. Sorry.
It's 2013 to 2014, 2.
the decision of the first time since 1957. Parliament ought to be given opportunity of expressing a view. That is why it is so. But may I then quickly?
No.
My lady, you realize that even though they've had 2 bites and I'm just having a small bite, you still want to. Oh no, this is on a lighter note. Then the last case of Equam. And the learned Attorney General cited the case of Abu Ramadan, in which the court said, well, it will intervene in every instance in which an arm of government or an independent body is crossing the line. But a key point that was made in that case is the fact that when we are dealing with discretion, the court's position is not to substitute its discretion for that of the person who is required to exercise that discretion. And in this particular case, we have the prayer for eventual determination by the court is even twofold. One, the manner in which the discretion should be exercised. Whether if the person presiding decides that if it's sat in the position of the person presiding, this will be his position. And the court has said in the Odoi case that when we get to that bridge, we will cross. In fact, that bridge is still far away. Because by the time it gets to the presidency, for him to exercise all of that, it will be dry, and they'll fix it. And so, my lords, when we now get to the specific ingredients that my learned friend, the plaintiff, was making as to the fact that they had made out a prima facie case and all of that, I've already submitted to the court that in every constitutional matter, constitutional issues will be raised. But in the one-sided decisions of this court, the court has always thought that it should not interfere with the powers of another arm of government, especially when, unlike in the Ghana independent broadcasting case, there is no imminent yes, I've seen a newspaper publication. And yes, I'm very to fact, an official document of Parliament in this particular court, I'm urging on the court, and the court needs more. As for a newspaper, we don't want to consider it. But in any event, the question arises, and the Attorney General rightly pointed out, that if it is true that these persons were attacked and their human rights were violated, this is not the forum. Just like the argument that we should transpose the fiscal impact analysis requirement in an act of Parliament and bring it into the Constitution so as to bring it within the jurisdiction of this court for determination. That matter is already before the High Court between us. So we can't be bringing that matter to the attention of this court and ask this court to make a determination on that. Then, on the balance of convenience, the authorities make it clear. Once it is within the province of Parliament to determine these issues, and the matter is still going through the process, this court will be presumptively injuncting a situation that does not arise and will never arise. At all, there's no danger at all. In fact, in this, I've amended that position. There is no danger at all, especially that.
You amended the word danger.
All right, Mr. Sorry, do I understand you to be saying that, correct me if I'm wrong, Parliament hasn't concluded the processes, so at this stage, injuncting Parliament is not the way to do?
Absolutely. So far as the legislative process
you are so so their deliberating includes transmitting and all them. You are so telling us that Parliament hasn't concluded its work so far as this bill is concerned.
Absolutely not.
And therefore, at this stage, injuncting Parliament, an arm of government, is not the way to go. Is that your argument?
Absolutely. In fact, that argument has a double, is two-pronged. Yes, but that argument is even two-pronged. First of all, it has not concluded because of the likelihood that it could still come back to Parliament. Once there's always that likelihood, yes. Two, even if that were the case, the legislative position is that that bill can stay as a bill for as long as it will stay as a bill. Because unless assented to, it won't be a bill. It won't be an act. It won't be an act. And so, once the court itself has noticed, why is the Attorney General who could advise the President to refuse assent, saying that this court should injunct a process that is capable of taking care of itself? That the President has too many options. My lady, I'm sorry. The President has too many options insofar as this particular matter is concerned. And so this court should not be intervening in a matter so clear as this. And as for the arguments about the seriousness and the gravity, I've already answered that. That every matter that comes before this court is of grievous consequences once the Constitution is mentioned.
Are you almost done?
He's done.
Oh, my lady, I can actually wind up. But I've referred because it didn't come out earlier, but there was this point about the Road Traffic Act 2. That was a private member's bill that had similar consequences, and it was assented to. The President could have decided not to assent to it, even though it has had the same consequences. No fiscal impact analysis matter, which should not even arise in this court, was raised, and there's no question as to whether there was a detailed note by the person presiding whether it will have that impact or not. So on all of the tests, on all of the facts, this application should not see the light of day. It should abide the fate of all such applications that have come before this court. We pray accordingly.
Just a quick point to assist the court. A point in the settlement of case by my late friend, counsel for the first defendant. My lady would note at page 5, a settlement of case filed on 14th March 2024. The first defendant admitting to
the substantive suit. This is the application.
Yes, I agree. But the admitted facts there are very important. Because he admits the absence of a fiscal impact analysis nor a document detailing the financial implications. Then he also admits, most materially, that the first defendant referred the bill to the committee without an opinion as to whether or not the bill imposes a financial burden on the state. So I think the question asked by my Lord Justice Gau, sitting on your right respectfully, has been answered. Now indeed the first defendant actually admitted in his testimony case that he didn't actually present an opinion. And that is why I was actually unable to point to an ascertainable record by which the first defendant expressed an opinion as to whether there had been compliance at
Honorable Attorney General, I thought that you were actually going to speak to a legal point, but you haven't spoken to it, and I'm not going to invite you to speak to it.
One.
No.
But the rest are legal. The main points are legal.
Yes, thank you.
Right.
But if you notice, Mr. Sori raised, one of the grounds for seizing jurisdiction over a constitutional matter is if there is a dispute regarding the meaning of, and his position is that Article 108, the focus should be on whether the bill makes provision.
Yes.
And your position, which echoes that of the applicant, is what Article 108 is saying is that whether the focus should be on imposition of a charge.
Yes. Especially my focus is a bill which has the effect.
The effect
of imposing a charge.
Of imposing it.
Especially, I actually say that indeed, if the court were to look at the manner in which similar provisions had been formulated in previous constitutions of the Republic, the court would note that it's actually the effect of such a bill that is important. So the words or the phrase makes provision for. The phrase makes provision for does not make a difference at all. Because in the 1957 Constitution, the provision was more direct. As in, it's stated as follows. Article 41, Clause 2. The formulation was in these terms: except with the recommendation or consent of the Governor General signified thereto, the Assembly shall not proceed upon any bill.
He's
re-arguing, eh?
He's re-arguing completely.
I beg your pardon?
He's re-arguing.
No, my lady, I'm seeking to answer your point as to whether the words or the phrase makes any provision, makes any difference at all. But I'm saying that it doesn't make any difference at all.
Give me a minute, sir. Right. Mr. Sori, you will notice that you, as first respondent, introduced this. You introduced this point of the necessity of putting the focus on the words makes provision for. So I think it's appropriate that the Attorney General.
My lady, I don't know that he got up, he read the provision entirely. And so if I get up and I'm responding to his arguments, I say, look, the provision is not just what you are reading, it includes this. I don't see what, it is now in the court's province to decide which of the competing arguments to deal with. Otherwise, at every point in time that the provision, then the other persons also get up to urge his view, and I can get up and urge another part of it that shows why it is not correct. So it's not a table tennis battle between me and him. He read it. He had every opportunity to draw the court's attention to each part of it.
Thank you. Thank you.
Most grateful.
Lady, I'm quite surprised. Like when the court asks a question related to a specific matter, I cannot address the court on it. But my answer to the court, with all respect, is that the words makes any provision for does not make a difference at all. Indeed, it is the effect of the bill that the provision in the Constitution is concerned with. So the concern with Article 181 is the effect of the bill. And respectfully, I submit that it is buttressed by the manner in which the similar provision had been previously worded in other constitutions the nation has had. Right.
Thank you very much.
There was also a point made by my late friend about the fact that the determination had been made, again a point of law. But the point of law is that the determination is not by the Committee of Parliament. And therefore, the exhibit my late friend relied on, which is exhibit 3, the report to the Committee of Parliament, is irrelevant. It's a determination by the Speaker or the person presiding. And indeed, the determination is made even before the referral to the committee. The determination required by Article 108 is actually at the beginning, it's at the front of the process. It's not in the middle or at the end. It's a determination at the front of the process. That is why the prohibition in Article 108 is very important. It says Parliament shall not proceed unless. So
your point is captured.
That's right. Again, another last point is that indeed the cases that my dear friend indicated that concern themselves with the introduction of an ally in Parliament. And it's urging on the court the fact that those cases related to the introduction of an ally in Parliament, and for that matter, they are different from this one. Really, the difference is, with all respect, does not arise at all. There's no difference at all. They all have to do with laws passed by Parliament, or laws that were supposed to be dealt with by Parliament. And indeed, an ally or a statutory legislation forms part of the body of laws in Article 11, Clause 7 of the Constitution. Article 11, Clause 1, respectively, of the Constitution.
AG, what he said was that because he used the word danger, because after 21 days it was going to ripen into a full law. So there was a danger, let me quote it, danger, irreparable damage when 21 days passed and then it will ripen into a law. That was why they injuncted the process.
Mr. Phil, there's no such danger at all, because Article 11, Clause 7 actually also imposes on Parliament a remedy. Parliament has the power to annul such a period. So there's no such danger at all. Very respectful. Very respectful.
Or submissions. The court will rise for a few minutes.
You may resume your seats, or you can stretch.